Faisal Manat.
So I believe he has applied for leave of absence. He's away.
Yes. Okay. Mr. Christy Souza.
Sir, children need protection where they are vulnerable because of physical domestic abuse. The state must swiftly intervene. Laws that allow swift intervention are key. Before going into my points proper on the bill, I would like to put on record my thanks to the hardworking and committed MSF officers who give of themselves in their calling, their duty, to serve and protect among the most vulnerable in our society. Sir, I return to my points on the bill. 10 years ago, in 2009, MSF investigated 272 cases of child abuse involving family members. Fast forward 5 years, in 2014, MSF investigated 381 such cases. By 2018, MSF investigated 1,163 in 1 year alone. Among last year's investigations, about half were physical abuse cases, while about 20% involved sexual abuse. Remember, these abuse cases involve a family member. Not just statistics, these numbers reflect the number of young lives affected by domestic abuse. Children put into perspective the importance of the Children and Young Persons Act, CYPA, which this bill amends. Sir, I would like to talk about 4 aspects. 1, how the bill extends the applicability of the Children and Young Persons Act. 2, how youths are treated in the criminal justice system. 3, how the bill provides greater support for caregivers. And 4, how the bill provides greater discretion to MSF officers as to determining at points of intervention. Firstly, this bill extends the protection under the CYPA to more people. Clause 21B and 22B amends the definition of young persons, extending the applicability of the Act from those 16 years of age and below to those 18 years of age and below. This brings it in line with some other statutes, such as the Prevention of Human Trafficking Act, which draws the line between adult and child protection at 18 years of age. This is to be welcomed. Besides amending the definition for young persons to include those 18 and under, child trafficking offences in the Children and Young Persons Act are extended from just children to include young persons. Clause 10 amends the heading for sections 12 to 18 so that the trafficking offences apply to children and young persons. This again is to be welcomed. The words of the offences have similarly been expanded. This is to be welcomed. For instance, Section 12, prohibiting the transfer of possession, custody or control of a child for valuable consideration, has been amended by Clause 11, extending it to young persons. Secondly, Mr. Speaker, this bill tweaks how youths are treated in the criminal justice system. Where the offence is under the CYPA, the new Section 84B ensures that the victim's identity is held in strict confidence, even after the victim turns 18 years of age. It may seem a slight amendment, but actually it has major positive consequences. The judge is also able to order takedown of publications in media as well as on social media. Exceptions are at the court's discretion in the interests of justice, as stated in the new Section 84B2. Director General and Protector have stronger powers of investigation in the new Section 8. For instance, although self-incriminating information cannot be withheld, they are inadmissible unless false information is provided. As it is difficult for victims to retell the horrendous stories of abuse, would the Minister therefore provide an update on what is being done to minimize the trauma involved in recounting the harrowing experience, especially in court settings? Several changes to the CYPA also better support the youth offenders' rehabilitation and now reintegration into society, trying as best as possible that the past does not hold them back from achieving their potential and that they can continue to have hope for their future. One way is to allow sentences meted out by the youth court to be deemed as spent at the end of completing the supervision, detention, community sentence or fine, without needing to wait the normal 3 or so years. This is provided for in Clause 73 and allows youth offenders to more easily reintegrate into society as they can declare that they have no criminal record. This enables the youth offender to turn over a new leaf. In fact, it creates a supporting scaffold structure around the youth, such as to be able to turn over a new leaf. So another key amendment here. Another way is by the extension of the Children and Young Persons Act to those 18 and under, and not just those 16 and below. This provides young offenders access to a criminal justice system which places emphasis on rehabilitation and reintegration so that the mistakes of the past do not continue to haunt the young person when he or she is older. One way is providing for the youth offender's identity to be kept confidential for life, and not just while he is still a young person, unless he or she reoffends. This is provided for in Clause 50. This allows the young person space to grow and change without being shackled to his past. Another example, and a good example, is Clause 27A, read with the second schedule within the bill, which allows for prosecution or the court to transmit cases involving the causing of grievous hurt, certain misuse of drugs offences, and other more serious offences to the court of appropriate jurisdiction. This is especially important for the Misuse of Drugs Act offences, as we do not want our young persons to become targets for drug syndicates to hire them or manipulate them as mules just because they are specially treated by our criminal justice system or the youth courts. Thirdly, this bill provides greater support for those who care for children and young persons. In particular, I want to highlight the support that this bill strives towards fostering. Clause 57 extends childcare leave to include foster children and allows the foster parent to disclose information necessary for this purpose. It is good that foster parents are supported in taking care of the children. They need the same kind of leave to be present for their children, for instance, if the child is sick or at a parent-teachers meeting. They also need it in order to better ease a foster child into the family and bring the child for therapy sessions if therapy is necessary. By better supporting foster parents, hopefully more loving families will be willing to step up and provide a loving and caring environment for children and young persons, showing the foster child what family and parents' love looks like. And thereafter, hopefully, the child can be adopted either by the foster parent or parents who are hoping to adopt a child. Or, if there can be reconciliation with the child's biological parents and the fostered child, then, if possible, the child can be reunited with the family, provided it is indeed safe. Fourthly, and ultimately, sir, this bill addresses child abuse within the family, particularly tackling the question, at what point is it in the best interests of the child or young person that the state intervenes in the parent-child relationship? On one hand, the protection of the child and hence the child's welfare and best interests are at risk. On the other hand, the benefit of being cared for by his or her parent or guardian is significant. As mentioned in the beginning of my speech, the number of child abuse cases are concerning. Even as we seek to find a better balance, we must also ensure that the broader discretion given to child protection service officers achieves deterrence of child abuse. And that deterrence must come with powers to act swiftly. When a child is abused, a child's life is at stake, not just physical, but also the long-lasting emotional trauma from being emotionally or psychologically abused. Swift intervention is therefore necessary. It is a basic ingredient that I am supportive of. The broader discretion through this bill allows the Child Protection Service officers to make the necessary judgment as to when that intervention is necessary. With regard to the amended Section 4.2, which sets out specific examples of emotional or psychological abuse, I do have a few clarifications for the Minister. Paragraph A mentions well-being and a sense of self-worth. How will this provision operate? Paragraph B mentions that threatening to physically hurt the child or young person is child abuse. Will the Minister clarify how this provision is to be understood in the context of Section 64 of the Women's Charter, where correction is an exception to family violence? Paragraph D says that confining a child or young person to a small space for the purposes of discipline is considered abuse. Would the Minister elaborate on what is intended by the phrase, any small space? Paragraph E talks about influencing the development of self-destructive, criminal, deviant or other maladaptive behavior. Would the good Minister explain what is meant by influence, deviant and antisocial behavior? Also, would the Minister explain what infantilizing means in illustration B? Notwithstanding my clarifications above, Mr. Speaker, sir, it is important that enough latitude and discretion be given to Child Protection Service officers for swift intervention where necessary. Would the Minister explain also the process of investigating a possible child abuse case and elaborate on the thoughts that go towards deciding how a child abuse case is best managed? In particular, under what circumstances will a child be removed from his or her parents, and if that happens, will the child still have opportunity to meet and even reconcile with his or her parents under appropriate circumstances? This amendment broadens the discretion of the Child Protection Service officers and allows them to intervene swiftly when necessary. Would the Minister elaborate on whether there is sufficient resources, particularly manpower, to exercise that broad discretion given to the officers in light of the unfortunately increasing number of cases investigated, as well as the expansion and definition of child abuse through this bill? As a significant number of child abuse cases involve children under the age of 7, the tender age of 7, would the Minister also elaborate on how have childcare teachers been trained to be able to detect child abuse? In conclusion, sir, this bill consolidates an extensive review of the Children and Young Persons Act, putting into law amendments that can better support caregivers, youth victims, youth offenders and child abuse victims. Sir, as I had stated at the start of my speech, children need protection where they are vulnerable because of physical domestic abuse. The state must swiftly intervene. Laws that allow swift intervention are key, and for those reasons, I support this bill.